Karina, my lovely prometida.
Hola.
And we have our NOA 1 letter, we have our NOA 2 letter, we got our case number. Now we're just waiting for the National Visa Center to send us our welcome letter. And we waited 407 days for the NOA 2 letter. We waited 115 days for the case number, which I got after 2 inquiries. I live in the Panhandle of Florida near Pensacola, north of Navarre Beach, and Karina is from beautiful Venezuela, Caracas, Venezuela, actually the mountains of Venezuela, and she used to work in Caracas, and she is now a legal resident of Bogota, Colombia. So we're waiting for our adjudication. We're waiting for the National Visa Center to send our case to the embassy in Bogota, and that's what they told me on the last inquiry. They told me to wait, so we wait. But this video, ladies and gentlemen, boys and girls, is about the legal responsibilities you have as a sponsor to your beneficiary when you sign Form I-864, which is the Affidavit of Support. Now, I'm not an immigration attorney, I'm not a CPA, I'm not a doctor, I'm not an engineer. I don't work for USCIS, I don't work for the State Department, and I give you zero legal advice. But I've been through 2 K-1 visas and 1 spousal visa successfully. I know how to do this process like the back of my hand. So come on along and listen to this video. It's very important for the sponsors, whether you're male or female, it doesn't matter. The sponsors, this is legal information for you that you need to know about the Affidavit of Support, Form I-864. So let's talk about USCIS Form I-864, Affidavit of Support. You fill this form out. When you get to the United States of America, you get married, okay, within 90 days, Mr. Sponsor, Miss Sponsor, and you fill out this form for your beneficiary, okay, to promise the U.S. government that you're going to take care of your new wife or husband, okay? And it's part of the Immigration and Naturalization Act, okay? It's congressional law that you fill this out. And you include this form in your adjustment of status paperwork when you apply for the green card. When you sign this contract, this is a legal binding contract, an individual, a sponsor, agrees to use their financial resources to support the intending immigrants named on the affidavit. So you're promising the U.S. government that now you're married to the beneficiary from this, whatever country he or she came from, that you are going to support this person. Okay? The individual who signs the Affidavit of Support becomes the sponsor once the intending immigrant becomes a lawful permanent resident. It goes into effect when the green card, once you sign the form and you get the green card. Okay? Now, the sponsor is usually the petitioner who filed an immigration petition on behalf of the intending immigrant. Okay? Your K-1 visa, for example, or your spousal visa. Now, an affidavit of support is a legally enforceable contract between you, Mr. Sponsor, Miss Sponsor, and the United States government. And it is the sponsor's responsibility, and and this usually lasts until the family member or another individual becomes a U.S. citizen or is credited with 40 hours of work. Usually about 10 years it takes to get 40 hours of credit with the Social Security Administration. Or this person dies or returns back to his or her home country and abandons the green card. Okay, so you, Mr. Sponsor, once you sign that form and your beneficiary gets that green card, as your new husband or wife, you are responsible for this person, okay, until they become a U.S. citizen, until they reach 40 hours of work credit with the Social Security Administration. The person dies or the person returns to their home country. Okay, you got that? You're responsible. Now, what if you get a divorce? What if it doesn't work out? Still applies. If you get a divorce from your beneficiary, you, Mr. Sponsor, Miss Sponsor, have signed a legal contract with the government. You are still financially responsible for this person. So if this person you get a divorce from this person and they move to another state and lives in Montana or in Arizona or whatever, okay, you could be sued by this beneficiary if you don't support him or her. You can be sued. All right? Immigration will fall on the side of the beneficiary, not the sponsor. So you better understand that. So let's suppose you got a divorce, Mr. Sponsor, Miss Beneficiary. No problem. I mean, life happens, right? And your beneficiary stays in the United States with his or her green card, 2-year, 10-year, whatever. You, Mr. Sponsor, if that person, you are still responsible financially for that person. So if you file another K-1 visa for another person in a foreign country, you file your second K-1 visa, you have to include the person that you brought to the United States first and any of her kids as your dependents. When you fill out the I-129F, when you fill out the I-134 Declaration of Financial Support, when you fill out the I-864 Affidavit of Support, you have to include those people as part of your household, as part of your financial responsibility, even if you're divorced and he or she is living in a separate state. You're in California, he or she is in New Hampshire. Doesn't matter, okay? If you file a second K-1 visa or spousal visa, you have to include the persons that you brought to the United States originally on the first K-1 visa as a dependent, which means your household size will increase, okay? Do you understand what I'm saying? The only way, Mr. Sponsor, Miss Sponsor, you can avoid being financially responsible for your beneficiary if you get a divorce is if she dies or he dies, or if she or he returns back to her home country, or if she has reached or he has reached 40 work credits with the U.S. Social Security Administration, 40 hours of work credit. It takes about 10 years to get to that point, or that person becomes a U.S. citizen. Okay? Now the law concerning this affidavit of support is found in sections 212 parentheses A parentheses 4 and 213A of the Immigration and Nationality Act, INA, congressional law. Okay? So, and then the provisions for this law are codified in Title 8 of the Code of Federal Regulations, CFR, at 8 CFR 213 lowercase a. Now, I'm not an immigration attorney. I'm not giving you any legal advice here. Zero. I repeat that. Okay? But it's important that you understand your responsibilities as a sponsor to your beneficiary. Don't forget, ladies and gentlemen, boys and girls, I do a live stream 3 times a week, Mondays, Wednesdays, and Saturdays at 7 p.m. Central Time. See you at the live stream where I can answer all your questions in real time, not in just a video. Don't forget, ladies and gentlemen, be patient during this process. And I have 8 years experience doing this. I've been through 2 K-1 visas and a spousal visa successfully. So I know what I'm doing. I know what I'm talking about. Do you need an immigration attorney to process a K-1 visa? No. I would only get an immigration attorney to help you if you have a criminal record of some kind and you need the immigration attorney to review your court records to see if you qualify for the benefit. Okay, that's the only time you really need an immigration attorney to do this, to do the paperwork. Unless you are just plain lazy and don't feel like doing it yourself, then by all means hire a company or an immigration attorney to do it for you. But if you're not lazy, if you have the patience to do this, do it yourself and use that money for your wedding or your engagement party or your honeymoon or whatever. Thanks for watching, ladies and gentlemen, boys and girls. Hang in there and I will see you at the live stream.
I'll be back.